In this country, we have a justice system. We have the acts and statutes and we have legislation. We also have law, common law, natural law, God's law, all of that. Today, I just want to talk about legislation. I want to talk about the justice system and whether it's acting fairly. Now, a lot of people will already be rolling their eyes and going, well, of course it's not acting fairly. But we do have to have a system that is acting fairly for everybody involved, both parties, both the claimant and the defendant. Surely it's got to happen that way. Now, I've been having a number of emails from my viewers over the last few months, actually, in which they're saying things like, Richard, what can I do? I mean, now, by the way, I'm not offering any legal advice whatsoever. I'm not a lawyer or anything like that. I'm just here to question what's going on. So do not take anything I say as legal advice. However, I am getting these emails from people who are quite desperate. They've had problems with their council tax, and they've fallen behind for whatever reason. Some may purposely want to challenge whether it's a lawful situation to charge it. Other people, of course, have just financial problems and they've done the best they can, but they've fallen behind for whatever reason. Let's not worry about that reason. And they've ended up in court, and as a result of that, they've either attended court or they've been told they don't have to attend court, and they end up with a liability order to pay a certain amount of money. And maybe they couldn't pay that amount of money, or they refused to pay that amount of money, and they challenged it. But whatever happened, the bailiffs have come, they've gone banging on the door. Maybe they've had their house repossessed. Maybe you've had your car taken away from you. Or maybe you've just been under the fear of this, and the psychological worries of all of this has affected your health. Maybe you've lost money, or maybe you've been charged an amount of money, and you're not quite sure, was justice actually done right? After all, we've been reporting here on this channel how incredible as it may seem, that particularly with the council tax, that there are bulk hearings, that a room is hired in a court, and that a judge is appointed. Whether he's acting on his oath or not is a moot point, really. And as people haven't turned up, they've been advised in some cases not to turn up to court. They've been summoned, but then said you don't have to attend. And perhaps 15,000, perhaps 20,000 cases are being seen in one day. You're not there. You're not there to hear the claim against you. You're not there to defend and say, well, I've tried paying this and I've paid a bit there and I've fallen behind, or whatever your hard luck story is, or whatever your defense is, you're not there to do it. And these stories have come out that these bulk hearings have basically rubber stamped, if you like, a liability order to say that you are now liable to pay whatever the court has awarded. Now, apparently, the liability order is only uttered, and we saw that, is only uttered by a judge verbally. I don't know if you remember that. Let's have another look at the document that said that, because I want to just go through this absolutely and make sure it's absolutely clear. This is the Justices Clerk Society procedure in liability order applications. Okay, it's a long document, but the essential bit is down here at number 4, orders. I'll just read it through. An order is made when the presiding justice pronounces it, i.e. he says it aloud, and is recorded in the court register. Since repeal of the prescribed order, there has been no court-produced order. Sorry, I'll read that again. There has been no court-produced order. So I don't quite understand how that, because it seems to sort of knock one out the other. I'll just read it again. Since repeal of the prescribed order, there has been no court-produced order. The council's software should generate a notice that, remember that word, the council's software should generate a notice that the order has been made, which is sent to the defendant. It is a notice at that point, and it is sent to the defendant. They should not be signed or endorsed with the name of a JP or court officer, still less the justice's clerk, right? And then it goes on to here to say some councils are still sending out their notification in the form of a liability order. But even so, it is not a court-generated document. It is notification of the order made by the justices. Now, so just to go over that again, the judge will say, he will announce it with a proclamation in court that there is a liability to pay whatever has been awarded against that defendant. Now, if you're not there to hear it, hello, I can't hear you, I'm at home, I'm not allowed in because there's a bulk hearing, you don't know what it is. But presumably, it, as it says in that document, is supposed to be recorded in the magistrate's court. So it's recorded. Great. Okay, so we've got that. It is recorded. However, the council, they need to know, obviously, what the sum has been awarded that the defendant has got to pay. So they're sending out a notice. Some people think that this notice is the actual order. Let's have a look at the notice then, shall we? Here is a typical notice that has been sent to me. And have a look at this. This is astonishing, is it not? The liability order here, it says, is in respect of council tax. Regulation 34 of the Council Tax Administration and Enforcement Regulations. This is at Milton Keynes Magistrates Court. Date 22nd of June 2021. Now, I can't see it awarded to anybody. There's no name, there's no address, there's no case number. It's just, that's it. Then it just simply says, on the complaint of Milton Keynes Council that the sums specified in the table below, I can't see a table below, can you? I mean, I know I've only got one eye, but please tell me, can you see a table below? Under Part 5 of the Council Tax Administration Enforcement Regulations 1992, due from the defendant, so whatever the sum is, due to the defendant, so specified to the complainant. They are outstanding. And there it is, you know. It doesn't say what the sum of money is. So how do you know how much has been awarded? And it doesn't say who the complainant is. I mean, the council doesn't say who it is. What council? Well, I suppose it's got to be Milton Keynes Milton Keynes Council, presumably, but it doesn't say it specifically. And look, signed by Justice of the Peace, look. And we saw categorically just now, did we not just see that? Did we not just see that? Here it is again. Look. Here, just this bit. If I can highlight it, there it is. They should not be signed or endorsed with the name of the JP or the court officer. And on that particular one, it is. That, my friends, is not a court, not a liability order. It's not a memorandum of the court. It's not the record the magistrate's court keeps. You want to see the record of the magistrate's court? This is what it should look like. Okay, so that's what you're being sent out. This, on the other hand, is what you should be seeing. And let me just go through that then. So at the top, you've got memorandum of an entry entered into the register. This one is at the Buckinghamshire Magistrates Court. And it's got here the Milton Keynes Magistrate Court, blah, blah, blah. And you've got the name of the person and their address and their gender. In this case, it was male. You've got a case number on the right-hand side. I've redacted it, obviously, for personal reasons. And you've got the informant in there, which is the Milton Keynes Council. And you've got all that sort of information. And so then you've got down here, number 1, the complaint for a liability order for non-payment of council tax and costs, and it's an awarded amount of money. In this case, £1,842.48. And the address of the place it's supposed to be for, in accordance with Regulation 34 of the Council Tax. Blah, blah, blah. Okay, then on the right-hand side of that, you've got liability order made for that amount of money, including the appropriate enforcement fee. So that is the end amount of money that's got to be collected. And as you can see at the bottom, it's got the date printed, it's got a line, and then it has the stamps. It's got the stamp of the date, 14th of December 2022, and then you've got the Berkshire Magistrates Court, and you've got the stamp. And then you've got another stamp saying it's certified as a true copy, very faint on the bottom right-hand corner. That is what the memorandum of the court entry should look like. Something like that. It might vary a little bit, but those basic details. That differs, ladies and gentlemen, from, let me just show you the other one, that one. It differs so much from that one. Now, if somebody's come to your house and said, here's the liability order, mate, we're repossessing your car, and you've let them take it away from you on the basis of a notice from the council, that is fraud. That is not this. And if it's not that, if it's not the magistrate's memorandum, a copy of, a true copy of, then what have they taken your car or house or fined you money or made you pay on the back of? And the thing is, you want to check that the court has the actual memorandum entry in it. Because it seems to me that a number of people have come to me and saying, well, I've rung them up. I've rung up the court and they don't have the entry. They do not have the entry. Now, if they don't have the entry and the council are generating on a bit of paper something, how do you know that the council's entry is correct? I mean, they may have made it up. They may have made a mistake. They may have got it wrong. They may have added a bit. That may not be enough. I mean, you're going on the basis that the person who has got the claim against you is now saying, oh, well, the court says you owe us this much. Well, you want to, I mean, and then they've sent the bully boys round, bashing on your door, taking your car away, going, oh, well, we've got the liability order. But is it really the liability order? Is it what the judge actually pronounced in court? Because he is supposed to do that. Rule 68. Now look, here we are. Let's have a quick look at the rules. Here we go. Magistrate Court Rules, 1981. Here we go. So now, Rule 68. There's a lot of rules they've got to abide by, I grant you. And let's scroll right down to 68 to see what it says. I'll leave the link in the description so you can have a nice bit of bedtime reading here. 66, it goes down, 67, I've gone past it here, 68, here we go. Proof of proceedings. This is the most important bit. The registrar of a magistrate's court or an extract from the register certified by the designated officer as a true extract shall be admissible in any legal proceedings as evidence of the proceedings of the court entered into the register. In other words, if you had to go back to court and say, actually, my car's been repossessed and I don't know why, you can go in with only acceptable is a copy, an extract of the register certified by a designated officer. In other words, not that, because that isn't certified by anybody. That's just a council printing it out. It needs to be that, to be lawful, to be legal, to be acceptable. So if you've had your car repossessed, if you've had your house repossessed, or even if you've paid money to the council, it may be that you haven't actually been awarded this fund, this money, or this, you haven't been told to pay this at all. So it may be advisable to go back to the magistrate's court and say, could I see the memorandum, please? Cite your case number and say, this is the case, this is the case. And now if they turn around and say, oh, we haven't got an entry for you. Well, you go, that's funny. I've just paid this bill. I've just paid, or I've had my house repossessed, or my car's been taken away, or they're in the process of doing it now. I want to see proof that the judge has made this judgment on me. I must see proof. I don't want a rubber stamp, do you know what? I want to see the actual court register. And it may be, and I'm not saying it is, and this isn't legal advice, but it may be that this is totally illegal, what is going on. Because if you can't see, if the magistrate court does not have a record of it, How do you know the council have given you a correct judgment? You can't, you can't, can you? Now, it may be that you've got a solicitor acting for you. You may be paying for a solicitor, and he has come back and just shown you the liability order from the council, or the so-called liability order. But has he shown you the magistrate's memorandum? And if he hasn't, demand to see it. And if he can't show it to you, demand that he get it. And if he can't get it, and he's not doing his job, then maybe the solicitor himself, who ought to know a lot better, maybe he needs to be complained to the SRA, the Solicitors Regulation Authority. And if people were to do that, maybe the solicitors would act properly, seeing as they're taking your money. I mean, despite the fact that they're probably taken an oath to the Private Bar Guild anyway, they've got their allegiance to the court first and you second, but let's leave that out of it. Are you, because so many people are writing to me, I only think it's fair to say, this is an unfair system and this is what's going on. You need to see the memorandum of the court register. You need a certified true copy. If your house or your car, or you've paid a bill on the basis of something the council have printed out, and it's not a real, true copy of the memorandum, a true liability order, then you have been diddled out of your money. And that is not good justice being practiced. And that's what we need to do something about.